Oh, okay, we're going to get started. Good afternoon. Um, uh, Welcome to our second webinar in recent months here. Most of you know me, but we may have a few newcomers on the call. I'm Bob Scott, president of Scott Strategic Investments. I've been in Pagosa Springs working with investors since 1998. Prior to that, I was an analyst on Wall Street and spent some time in private equity. I'm a certified financial planner, and we are a comprehensive wealth management firm. First of all, we hope that you and your family are mending from the disruption of COVID-19. Our thoughts continue to be with you during this period. As I mentioned, we just recently did another webinar. This is the second one in a series of online webinars we will be having over the next 6 months. Currently, our plan is to cover a number of topics that we are developing, but initially, we're planning the following. February, estate planning in the age of coronavirus. March, we're going to do a webinar on ESG investing with BlackRock. For those of you not familiar with BlackRock, they're the world's largest asset manager now. In April, how tax planning changes through 4 stages of retirement. May, Social Security planning. June, tax review and recovery. In July, a cybersecurity workshop. We will also have some market updates as the year progresses, and we may have some other webinars if we have the interest. We have a passion for educating investors and hope you find the information today useful. I would also say if there's a particular subject that you would like us to address or talk about or potentially have a webinar on, I'd love to hear about it. So feel free to drop me an email. Today, we're going to talk about estate planning in the time of coronavirus. If ever there was a time for people to get their affairs in order, this is it. No one is immune from the virus. Many of us are already feeling some anxiety about the state of our estate planning and may not be sure of the things we should be doing. Today, we're going to talk about estate planning in its entirety. Excuse me, we're not going to talk about estate planning in its entirety. Instead, we're going to focus on what can be done right now to offer some immediate protections. Later, when there is more time and travel restrictions have been fully lifted, you can come back to your estate plan and fill in the gaps. But for right now, there are several things you can do and should do. We know you have a lot going on in your life right now, but this is important. Today, I hope to help you understand the urgency of getting certain documents done, whether you are doing it for the first time or updating them in light of this vicious virus that now makes the possibility of serious illness and death more real. Before we begin, it is always important to review that there are 5 key areas of financial planning. A lot of you think of us as just the investment people, but we, as I mentioned, we're a wealth management firm, and we look at all of these areas. Preservation planning, retirement planning, tax planning, estate planning, and investment planning. As a comprehensive wealth management firm, we try to always consider the impact of any recommendation we make on not just one, but all of these areas for our clients. As of February, and let me just state up front, I've been working on this presentation for some time, and it's been, developments have been pretty dynamic and change every day. So I've done my best to present updated information here, but I think we all get the picture. As of February 21st, over 28 million infections have been confirmed in the US. More than 500,000 people have died from COVID-19. One thing that has made this even more difficult are the stay-at-home orders and quarantining. Many people are isolated from their families. If you can't talk to your kids or other loved ones, how will they know how you'd want to be cared for if you had to go to the hospital and be faced with the possibility of going on a ventilator? And then there's the isolation that occurs once a person gets sick and goes to the hospital. They're whisked away to the ICU or some other part of the hospital, and their loved ones are prohibited from seeing them. If they need to be intubated and put on a ventilator, they can't speak for themselves, and their spouses or sons or daughters aren't there to speak for them. And then there's the death, not the big data type of death, but the personal kind of death, the individual people who passed away long before their time, leaving loved ones confused and grief-stricken. These are just a few of the deaths highlighted in the New York Times. These people were not that old. This graphic from the Washington Post shows that COVID-19 is now the second leading cause of death in America today. It's killing people who had no underlying conditions or any reason to think they would die. The point is, this can happen to any of us. It literally is unfortunately, winning the lottery. I mean, I have a handful of friends that have all thankfully recovered, but my son and daughter-in-law were just recently diagnosed with COVID, and they're doing well. But even people taking a great deal of precautions are at risk. Here's what can go wrong if people are not prepared. Number one, there could be inappropriate medical decisions if there is no advance directive. Now, there are some unique considerations with regard to COVID-19. Some of you may have signed a living will saying you did not want to ever be put on a ventilator under any circumstances. But we've seen that ventilation is a relatively common treatment for COVID-19, and many people have recovered completely after spending some time on a ventilator, even people in their 90s. This right here is one reason to review any healthcare advance directives in light of this new illness. On the other hand, there may be reasons why you might not want to be put on a ventilator, such as not wanting to be left in a weakened state. The point is that medical personnel will do whatever it takes to keep a patient alive unless they are authorized to withhold certain treatments via an advance directive. Number two, no one is making financial decisions if there is no power of attorney. Say a small business owner gets sick, gets admitted to the ICU, and has no one authorized to carry on the business, meet payroll, conduct transactions, and so on. This could go on for weeks. Even individuals with relatively simple finances need someone to pay the bills, transfer money, and so on. So a power of attorney for finances is definitely essential. What if you don't make it? Assets would be in limbo if no estate planning measures are taken. Loved ones wouldn't know what to do or where to turn. So today, we're going to talk about the things you can do right now, things you can control, things you can do from home to put some of these estate planning measures into place. Again, this is not full-blown estate planning. For those of you who have done full-blown estate planning, all that may be necessary is a review of documents and maybe a call to the estate planning attorney to see if anything needs to be done. In this presentation, we're going to be talking about things you can do yourself without an attorney. But if you already have an attorney that you work with, by all means, seek your attorney's assistance. And as many of you have gotten used to me saying, nothing in this presentation constitutes legal advice. We are educating you on common estate planning documents and encourage you to seek professional legal advice for your own situation. Here are the essential estate planning measures that you can take right now from home. I'll be talking more detail about each one of these as we progress. First, an advance directive for healthcare. Second, a power of attorney for financial decisions. Third, make sure assets are titled properly and beneficiary designations are up to date. Fourth, a simple will to appoint an executor, and if applicable, a guardian for minor children. And fifth, letter to loved ones. As you're thinking about these things in relation to your own estate planning, don't forget to consider your other family members. Maybe you have parents who never did their estate planning or adult children. I think this is a very important point given my own situation and the age of my kids. An 18-year-old child would be considered a child by most of us, but they're an adult in the eyes of the law and HIPAA. In order for their parents to get information about their medical condition, there should be a HIPAA release signed by the child who is no longer a minor. Very important for those children that are kind of in that gray area between children and adults. We want to be able to help them if something happens. Planning for illness and incapacity. Advanced directives today generally combine a living will and a power of attorney. The living will allows you to state your healthcare wishes in the event you are unable to communicate or make decisions. The power of attorney allows you to appoint someone to interact with medical personnel on your behalf. Here are some of the advanced care goals that are usually listed on these documents. Then you decide which are more important to you and prioritize them, such as being free from pain, being with family, being able to feed, bathe, and take care of yourself, not being a financial burden to your family. It may also allow you to state preferences in case of terminal illness or irreversible brain damage. And it lets you state your end-of-life preferences, such as where to die, at home or in the hospital, and organ donation. Before COVID-19, going on a ventilator was usually considered a last resort. People who didn't want to be kept alive by artificial means would generally state that they did not want to go on a ventilator. But COVID has changed all this. Ventilators have saved thousands of lives, and while a lot of people do die after going off the ventilator, many others, especially younger people, recover. There have been articles on the lasting damage a ventilator can do to a person, such as extreme muscle weakness, inability to perform basic tasks like driving or grocery shopping, cognitive impairment, and a higher chance of dying over the next year. Obviously, you will have to use your judgment here. If someone is older and weaker to begin with, they may not want to go on a ventilator. And anyone who wouldn't want to end up in a compromised state may opt out of the ventilator. Others who would want to stay alive at any cost would want the ventilator and any other procedure that might keep them alive. The main thing is that people who already have living wills and who stated that they did not ever want to go on a ventilator may want to revisit that decision in light of COVID-19 and perhaps word it differently. These are tough decisions, and there is evidence, a lot of evidence, that people anticipating end of life don't really know how they will feel until they get there. It's easy to say you don't want to be kept alive by artificial means, but will you still feel that way when you're close to death? One reason people put off doing their advanced directive for healthcare is that they don't want to make these difficult decisions now. You know, that's why it's a good idea to also name a healthcare agent who can interact with doctors and make decisions on your behalf in real time. Without the living will, it's too much of a burden to place on loved ones. But without the healthcare power of attorney, you don't have someone covering the gray areas where the decision to go on a ventilator or have a feeding tube is not so clear cut. The healthcare agent can talk to doctors and listen to the prognosis and weigh the pros and cons at the time the health event is happening. When choosing a healthcare agent, it obviously should be someone you know and trust, and who also is competent and able to understand both your wishes and the treatment options. It's usually recommended that it be one person in order to avoid confusion and disagreements at the time quick decisions need to be made. So something to think about is to name a primary and a contingent agent. Usually, the healthcare agent is able to be in the hospital meeting with doctors in person, but during this pandemic, that's sometimes not possible. So some attorneys are recommending that the healthcare power of attorney have a provision for electronic communications by phone or email, and that it releases the medical team from liability if they take instructions that way. A lot of new things to think about given technology, et cetera, as we'll see as we progress through the presentation here today. Advanced directives are governed by state law. Most states require 2 witnesses or a notary. Some states require both. A little later, I'll be talking about the difficulty of getting papers signed during the shutdown and some possible workarounds. Here are some resources and sources for advanced directives. 5 Wishes is offered through an organization called Aging with Dignity. They offer the form for $5 as well as conversation tips for individuals and families. The 5 Wishes form has been approved by most states. Or you can download your state's form from the National Hospice and Palliative Care Organization. Most healthcare providers have their own form. You can call and ask your own doctor to email it to you. I'm a big fan of this 5 Wishes org, and we have some of those 5 Wishes brochures here. If somebody has trouble finding it or would like a hard copy, just reach out to us and we'll try to get it to you. Of course, while supplies last. Because it's so easy to let barriers stand in the way of doing the advanced directive, especially now that signing is so difficult, here is one idea. I think this is a pretty compelling route to go. Go to mydirectives.com. This form is all digital. You check the boxes to indicate your healthcare preferences and appoint your healthcare proxy online. You can choose a primary and a contingent person to interact with doctors on your behalf should you become unable to speak or give directions. The form is emailed to those people who are prompted to accept the assignment. Then to validate, you enter the names of 2 witnesses. An email is sent to them for their digital signature, and then the signed form is stored online. It can be forwarded to anyone you name, such as a healthcare provider. You can also download and print a PDF and a wallet card with a link to where the form is stored online. I suppose an attorney could question the legality of this form because the 2 witnesses do not literally witness your signature. It's all done digitally, but here's the thing about advanced directives. Some version of the form is better than none. It's hard today to get 2 witnesses together to sign the form. And let's face it, doctors and patients and family members are making life or death decisions all the time, usually without any advanced directive in place. Advanced directives are designed to reduce liability for the medical team. It essentially gives them permission to pull the plug. But in real life, doctors are discussing treatment options with family members and making the best decisions they can without worrying about litigation. An advanced directive does not force a doctor to do or not do a certain thing. It merely provides guidance on what the patient would want. If we get too hung up on the legalities of the signatures, we could be depriving the medical team of this important guidance. One last thing I want to say about the advanced directives is to reiterate this warning. If the advanced directive says no ventilator, it could cause life-saving treatment to be withheld if you have COVID-19. Most people, when they sign these things, assume they'll be on their deathbed when the ventilator consideration comes up. So check the language. If it says no ventilator, if no hope of recovery or some such language, it's probably okay. But if it says no ventilator under any circumstance, you may want to change it. And a final tip about healthcare. Make a grab and go envelope in case you have to be rushed to the hospital. This is a good idea, absent COVID-19. When there's a healthcare emergency, people don't always have their wits about them. It will be much easier on everyone if you have an envelope that is easy to grab that has these things in it. A copy of the healthcare directive, a list of medical conditions, a list of medications and allergies, the names and phone numbers of the primary care doctor and any other doctors or specialists, the healthcare proxy, and of course the insurance cards. Once you made up this envelope, keep it in an obvious place, like next to your keys or in a kitchen drawer that is quickly and easily accessible. And make sure your family knows where to find it. Okay, now let's talk about power of attorney for finances. This document gives another person the power to pay bills, transfer money, manage investments, buy or sell real estate, manage digital assets, and more. The power of attorney can issue broad powers or specific powers. The two characteristics you want in an agent are honesty and competence. You might choose a spouse, an adult child, or even a professional such as an accountant. What you want is a durable power of attorney. This means it takes effect immediately upon signing and remains in force until you revoke it or die. It specifically stays in force if you become incapacitated, which is the whole reason for doing it. The other kind is a springing power of attorney, which is not as good. A springing power of attorney doesn't go into effect until the happening of some specific event, usually a certification of incapacity. People sometimes do these because they don't want their agent taking over their finances before they become completely incapacitated. But today, with doctors so busy and no one able to meet in person, getting this certification of incapacity could be very difficult. If you're naming someone you trust, you shouldn't have to worry about that person taking over your finances while you are still able to take care of most things yourself. For a quick and dirty power of attorney that you can do yourself, just download a standard form from one of these websites: US Legal, Law Depot, or of course, LegalZoom. Now, there could be issues with the power of attorney when it comes to dealing with specific financial institutions. It's one thing to draw up and sign a power of attorney. It's sometimes another thing for the agent to actually be able to act when the time comes. Most banks and other institutions have their own form. So to be sure your agent is authorized to act, it would be best to get each institution's power of attorney form. The Social Security Administration does not recognize a power of attorney, but they have an advanced designation program that allows you to name a person to serve as a representative payee in case you become incapacitated. You can go to ssa.gov/my-account and open an account if you haven't already done so, and look for or click on the advanced designation button. If you have to put all your assets into a living trust, you may give the successor trustee the power to step in at any time and take over the management of trust assets. This serves the same purpose as the power of attorney, but it only deals with the assets in the trust. If there are any assets outside the trust, the successor trustee would not be able to deal with them. The same caveat goes for financial institutions. There could always be some question whether the institution would actually take instructions from the successor trustee. So it might be better to use the institution's own power of attorney form. You know, I feel like I'm going pretty fast. If anybody has any questions, please use the chat feature in Zoom, and we'll try to address those at the end. Of course, there's also issues for the power of attorney with regards to signing it. Some states require 2 witnesses and no notary. Some require 2 witnesses and a notary or a notary. So, you know, be clear what your state requires. You can go to LegalZoom to check the latest state laws. And by the way, if a power of attorney is valid in the state where it's signed, it will be valid in other states as well, such as when you are visiting another state. If you move, of course, it's best to have new documents drawn up or at least reviewed. In Colorado, I believe a notary public needs to witness your signature. Some states allow for remote online notarization, and I believe Colorado has adopted this. Both the client and the notary sign in real time using a webcam. Again, here's a list of some of the states that use it. Colorado was a new participant, but I'm 90% sure Colorado is allowing it now. Lawyers say that if remote notarization is not allowed, you'll have to get creative, such as signing in a car and witnessing through the windshield. Again, I imagine notaries are coming up with ideas quickly, so you can check with some of your local contacts on notarization. Okay, that takes care of quick and dirty incapacity planning. Once the pandemic has passed and life resumes to the new normal, you can revisit these plans and make whatever changes are necessary. But at least you'll have the basics and you'll have something for now. The unique thing about the coronavirus is how deadly it is. People who never expected to die are dying. And this is why everyone is so nervous and thinking about getting their affairs in order. I have a good friend who got coronavirus recently and didn't hear from him for a couple of weeks. Talked to him and he was still not fully recovered, but he thought he was going to die. And one of the things he said to me was, when he was not doing very well was, man, have I taken care of everything? So again, that's the idea of this webinar today is get things in order today and be prepared. And remember, you're not doing this for yourself. You'll be dead. You are doing this for the people you love. If you were to suddenly die, what are your loved ones going to do? So think about your spouse, your partner, adult children. Would they know what you have and where everything is? As soon as this presentation is over, I want you to sit down at your desk or kitchen table and pull out all of your account statements, your bank accounts, investment accounts, IRAs, retirement plans, insurance policies, everything. On one piece of paper, you should be able to write everything down that you have. The financial institution's account numbers and contact information, that is the people at the institution who should be notified in case of your death. Go online. Some institutions have specific instructions about this. Put yourself in your partner or son or daughter's shoes and ask, what do they need to know to pick up the pieces of my life? You want to approach death planning from the perspective of the people who will go on living. How can you make your death easiest for them? That's what getting your affairs in order today is all about. So, keeping in mind that we are talking about quick and dirty estate planning that you can do immediately, where something is better than nothing until you can get to the lawyers, we'll start with account titling and beneficiary designations. Why? Because at death, these assets pass directly to co-owners or beneficiaries outside of probate by operation of law. If you also have a will, these methods of ownership transfer supersede the will. Again, that's an important piece that I think is missed by people. These designations, again, supersede the will. In the case of bank and investment accounts, if these are owned as joint tenants and one owner dies, the co-owner assumes full ownership. Or if the accounts are titled as pay on death or transfer on death, the assets go to the named individual. Let's say you change the title of your bank account to pay on death or POD, listing the name of your daughter. When you die, all your daughter has to do is contact the bank and present evidence of your death, and the account will be retitled in her name. IRAs, retirement plans, and life insurance all pass by beneficiary designation. This is also one of the most direct ways to transfer assets. All your beneficiary needs to do is contact the institution and present a death certificate, and the account will be retitled in their name. Same with life insurance. Proceeds are immediately paid out to them without going through a court of law. But we can't emphasize enough the importance of informing your loved ones about these assets. You don't really want them to have to dig through your papers looking for possible accounts and insurance policies that may or may not exist. 27 states allow transfer on death deeds for real estate. If your state allows for transfer on death deeds for real estate, you can set it up so your beneficiary is able to immediately retitle your house or other real estate without going through a court. You can get the form through your county auditor or documents office. You may have to pay a recording fee, and it would have to be notarized. Once you have all of your accounts set up to pass to your loved ones by beneficiary designation or pay on death or transfer on death, it will be very easy to have title transferred to them without going through a court. This will make it very easy on them at the time they're grieving your death. Now, it should be mentioned that if you have a complicated family situation, maybe a second marriage or a blended family or multiple beneficiaries that you want to leave different amounts to, these simple methods do not work as well. In those situations, you really should see an attorney who will be able to customize your bequest wishes and make sure they go to the right people with a minimum of hassles and fees. If you are able to have most of your assets pass through joint ownership or beneficiary designation or pay on death or transfer on death, your estate may qualify for a small estate probate exemption. If the assets passing outside these methods are under a certain amount, your loved ones won't have to go to court to settle your estate. Here's an example of a case where a single person dies owning nearly $1 million worth of assets, but only $35,000 worth of personal property would be subject to probate because the rest of it transfers by beneficiary designation or operation of law. If the $35,000 is under the state's small estate exemption, there would be no probate and no court involved at all. If everything is passing outside of probate, you don't even really need a will because it won't be going to court. But it's still a good idea to have one so you can put someone in charge of distributing the remaining assets, deciding who gets the car, and so on. If there are minor children, you definitely need a will in order to name a guardian. Again, talking quick and dirty here, you can go online and download a do-it-yourself will from Quicken, Willmaker, or LegalZoom, or Law Depot. These do-it-yourself wills are valid if signed and witnessed by 2 witnesses. Of course, and this is easing, but we've had issues with the shutdown and quarantine problem. How do you get 2 witnesses to sign your will if everyone is shut up in their homes? So you might want to make a holographic will. This is a handwritten will that does not need to be witnessed. There could be some legal complications if it were admitted in court and if it were contested, but small estates don't go to court. This is really just a way to tell your partner or children what to do with your stuff and presumes nobody will contest it. Once the advance directive and power of attorney have been signed, the accounts titled properly and the beneficiary designations updated and the will drawn up, the last thing is the letter to loved ones. Again, the important thing is to look at your death from your survivor's point of view. What can you tell them to make life easier for them? First are the practical matters: how to get into the house, get the mail, care for the pets. This is basically telling the loved ones how to pick up where you left off. You'll want to write down a list of all of your bank and investment accounts, the name of each institution, account numbers, and contacts. You'll want a list of people to be notified at the time of death, like your employer, advisors, family, and friends, including a listing and location of ownership papers, like deeds, insurance policies, and vehicle titles. A listing and location of valuables, and last but not least, website logins and passwords. This whole world of website logins and passwords gets into a lot of legal gray areas. If your daughter has access to your computer master password and the computer's keychain has all your passwords stored, what's to keep her from logging onto your bank account after you're dead and moving money around? What's to keep her from reading all your emails or posting on Facebook? Now, you probably trust your kids and feel that giving them access to your computer will make their lives easier, not harder after your death. But you have to wonder about all the legalities of this. Most online entities like Facebook and email providers have policies and procedures that need to be followed in case of death. And I'm sure we've all read the 300-page terms of service agreements, word for word, so we know exactly how these work. Anyways, but think about what a nightmare it would be forcing loved ones to check each company's policies before they can deal with the online account. This is too big a discussion for this forum, but the point is you may want to leave behind a letter of some sort telling your loved ones what you have and where everything is. And then there are all the sentiments that need to be expressed. I had never seen this before until I started doing some research for this webinar. The Stanford Letter Project is a great idea. You do a life review, and in your letter, you acknowledge the important people in your life. You remember treasured moments from your life. You apologize to those you love if you have hurt them. You forgive those who love you if they have hurt you. You express your gratitude for all the love and care you have received. You tell your family and friends how much you love them. And you take a moment to say goodbye. It doesn't have to be complicated or long and involved. Again, the thrust of this presentation today is something is better than nothing. Just start jotting down some of these, just start jotting some of these things down. I'd encourage you to go to the website and check it out. It's pretty cool. Here is a summary of steps for our quick and dirty COVID-19 estate planning. Right now, complete and sign a healthcare directive that combines a living will stating your wishes on how you want to be treated and the names of the person you want to serve as your healthcare proxy. Number 2, complete and sign a power of attorney for finances. Number 3, check account titling and beneficiary designations. Number 4, draft a simple will and write a letter to loved ones. That's number 5. These steps will go a long way to easing your estate planning fears. Hopefully, nothing will happen to you, but you will feel much better having these things done. Then, once the ball is rolling, you can go do a more comprehensive estate plan. Organize your records, call an attorney, and work on your legacy. Here is a screenshot of our legacy planning checklist that we use to help clients get organized. It's a checklist of things that need to be done to complete your estate plan. The things we talked about today will get you by if you become incapacitated and unable to express your medical wishes or take care of your accounts. But there's more to estate planning than those things. Once you've done the serious aspects of estate planning, you can get to the, I guess we could call it the fun part. This is what we call legacy planning, which is passing down all those intangible things like memories, family stories, values, beliefs, and so on. How do you want your children and grandchildren to remember you? These worksheets will jog your memory by asking you to write down things like significant life events, your family ancestry, what life was like when you were growing up and where you lived and traveled, relationships, family, favorite things, views, and values. Each worksheet has questions that will help you remember some of these things, and your children and grandchildren will appreciate it. These memories could be lost forever if you don't capture them now. I'm glad those of you that tuned in are here today. Many people put off doing their estate plan, and family really does suffer when it isn't done. If the corona virus has motivated you to start getting some of your estate affairs in order, then I guess we can say it's one of the few good things to come out of this pandemic. Today, we talked about the most essential things that need to be done. I hope this was helpful and put you on a path to a more complete estate plan. Your legacy will be set when, one, a trusted person is ready to step in and help if it becomes necessary. Two, your records are organized and accessible. Three, your loved ones will be provided for after your death. And four, you will be remembered for your unique contributions to the world. Again, this is pretty simple, pretty straightforward, not hard. You just got to get started and put pen to paper. Thank everybody for your time today. I hope you learned valuable information. If you would like to learn more, or if you want the legacy planning materials that I mentioned just now, please give us a call or shoot us an email with the contact information you see here. As I have mentioned in our previous webinars, we are happy to provide a free consultation to review your individual situation. Again, we're comprehensive wealth managers. We look at the whole picture. Happy to meet with you over the phone or via Zoom or in the office. Let us know how we can help. With that, let's see if there's any questions. Doesn't look like there is, which must mean that I answered everybody's questions. Okay, well, everybody get your estate plan in order and call us if we can help. Appreciate you tuning in. Thanks again.